Over to you, Mrs. Mutambu.
Evening, everybody. Thank you, Shepherd. Happy Sabbath. We'll start with a word of prayer. Let us pray. Our Father, who art in heaven, we want to thank you, Lord, for this time that you've given us. We want to thank you for the blessed Sabbath rest. May you be with us, Lord, as we're getting into this session, Heavenly Father. May we be informed, may we be enriched, and may you help us, Lord, to be proactive and to act on the things that we would have learned to better our lives and that of our future generations. I pray in Jesus' name, amen. So I will hand over to Arthur. Arthur.
Thank you so much, Laura. Today, please allow me not to use video. My internet is dragging a bit. I hope that is okay. I hope that is agreeable with everybody, because I also want to ensure that we can have a seamless conversation today. So yesterday, I got to join. I thought that was my presentation day. Then later I actually realized we'd exhausted quite a number of things on the things that we're supposed to talk about. So what I want us to do today, I think we might need to actually focus more on questions and answers. That way I think we get to learn and benefit more from answering the specific issues that maybe some of us may be having. Because I realized from what we did yesterday, we covered quite a number of issues. So I don't know if we may be having any burning questions that would make it easy for me to go forward. We can use the chat section to start with. And pretty much yesterday I was presenting on the Zimbabwean side, and Shunga, I think, did a lot of justice to present on the legal side insofar as marital laws are concerned in South Africa, and also inheritance issues. And in Zim, just to do a recap, we stress that with 3 marriages. The first one, not necessarily a marriage in the general sense, but it's a marriage for purposes of inheritance and also for purposes of maintenance. And it's also considered a marriage for purposes of bigamy. Bigamy is where you're contracted in terms of Chapter 5.11 and you engage in another marriage, even if it's an unregistered customary law union. By operation of the law, is deemed to be a marriage. So the first one is an unregistered customary law union, which is the majority of the setups that we find in most homes today, the unregistered customary law union. Then besides the unregistered customary law union, we have got the next one, the African Customary Marriages Act. So that one is pretty much a registered version of the African marriage. So it's found in terms of Chapter 5.07. And like I discussed yesterday, it allows a man to have more than one wife. It allows a man to have more than one wife. However, it doesn't allow the opposite. So that marriage I explained in terms of consequences. The first two, the setup pretty much is an in-community of property setup. That's the main difference with the civil marriage, the Chapter 5.11, which is an out-of-community setup. So those first two, they are the in-community of property. Then the civil marriage, the Chapter 5.11 is out of community of property. And remember from the conversation we had yesterday was, if you're married out of community of property, it means both parties are able to actually acquire properties in their own names, even though they're married. That's what happens with an in-community of property setup, which is why I want to encourage all of us to get to be knowledgeable regarding the type of marriage that we have. So if you have any particular issue that you want me to address, you can also send it anonymously. I won't read your name. Please feel free to send them anonymously and ensure that you just send it through. Your question may actually also be helping somebody. So remember, for those who are in out-of-community setups, especially those with marriages in Zimbabwe, one of the consequences of an out-of-community property marriage is it allows you to give away your property on inheritance to anyone else you want besides your spouse. Because as long as you're out of community of property, it means both parties are entitled to own property separately. and it means you can give away your property. So there's a question that has come to my inbox directly, and I'm keeping in this anonymous as well, is what can one do if husband is property in South Africa, but does not want to make you sign on the property, married in Zimbabwe, staying in South Africa? So these are the implications. Remember the conversation Shungo was having with you guys yesterday, that if you're married in Zimbabwe, if your marriage is registered in Zimbabwe, it's pretty much the legal regime that governs that particular marriage in Zimbabwe that applies even if you're in South Africa. So what it means is you are married out of community of property. So what it means, if your husband is only registered, is the person who is registered, pretty much if they were title deeds, that becomes prima facie proof of ownership. It means they are the owner of that particular property. So there are complications that arise in the event that he decides to do whatever with the property, especially if you have been contributing to that acquisition of that property. So what do you do? I really think this is not necessarily a remedy where you can find in terms of law, but pretty much it's going to go into the substance of your marriage, where you say, this is the state of affairs, what can we do? But legally, the remedies that are available are usually it's divorce. But now, at this stage, it becomes very difficult. So I think the actual remedy is to get marriage counseling, get advice from people possibly who are in similar setups, and also get understand how they manage to survive or to navigate that. It can also help you in terms of protecting. And by the way, remember the conversation we were having yesterday around let's try to encourage trust in our marriages. It's very difficult, very painful to be in a trustless relationship where you don't trust the person you're working with, acquiring properties. I think that really even discourages people from working. So that will be my advice pretty much. You also just need to get a way of counseling from people who may have been in those situations. And especially if there are some people who have gone through that, you may also inbox so that we can read for the benefit of the person that has sent through the question. So like I indicated, please send through any questions that you may have so that I'll be answering. But I think what we did yesterday, we actually did extensive coverage of the laws governing marriages and governing as well inheritance. Laura, I don't know if you have any questions that have been sent through to you.
Yes, there are questions that I put in the group, in our group, Arthur, yesterday.
All right, let me try. If you have them close by, if you don't mind, you can actually put them in the comment section, on the chat section, so that we're able to all see what is.
Okay, let me read out the one. It says, I want to know an example of an ANC with a crow, where when it's time to divide the assets. Then secondly, the will is a legal document. Who then represents you when the initial lawyer has passed away? So the first is an example of an ANC with a crow, and when it's time to divide assets. When it's time to divide assets. And then secondly, it's the will executed once the lawyer who initially wrote it has passed on.
All right. So I think what the first bit, I'll actually wait for Shungo to respond on that. I think she'd done justice in addressing that particular aspect. So I think Shungo will be joining us just now. I think should be answering.
Yeah.
Perfect. Can you answer the first one? That'd be great. I think you can respond to this one.
Okay, so with regards to ANC with accrual, I don't know, Arthur, if you have that system in Zimbabwe, because it's applicable to South Africa.
No, I'm not aware. That's actually I also want to.
Okay, so this is a South African type of marital regime. What happens is this: the simple basis of it is that when you start the marriage, whatever the value of each one's estate is recorded. That on the date we got married, Mrs. came with 0, Mr. came with 20. Let's say you then divorce 10 years down the line. We have to look again at the value of each estate to see whose estate has grown more than the others. So because you're married with an out of community of property with accrual, you are the one whose estate has grown less is entitled to 50% of the growth that took place from the date we got married to the date we got divorced. So let's say the estate has grown by $1 million. The other spouse would be entitled to 500,000 because that is 50% of $1 million. That's growth from the date they got married to the date they're now getting divorced. And that is an example of how a out of community of property with accrual works. That's just an example of that aspect. But there are different types of out of community of property with accrual, because you can then have out of community of property without accrual. No one shares anything. You live with what you came with. Then there's out of community of property with accrual, without profit and loss. There's a different formula applied. And then out of community of property with accrual, with profit and loss, also a different formula. So it all goes with the variation that you'll have chosen regarding the out of community of property. But this regime is applicable to South African marriages. Like Arthur has indicated, he's not aware of it in Zim. So whoever was asking, I hope it's applicable to you. Okay.
Yeah, you see how complicated.
It's very complicated. But because South Africa now has sufficient practice in it, there are people who actually specialize in drafting those antenuptials and in enforcing them at the time of divorce, and also if need arises in terms of death and wills and all that. But it's a complex thing. It's a somewhat redistribution kind of thing, but there's a particular formula applied in order to use it.
Yeah, that's interesting. Thanks so much, Shingo, for that.
Okay.
No, that's why I like my legal system.
No, I think it's justified in that in some instances where a wife is able to show that even though I was not contributing economically in terms of money, the reason why my husband became successful to the point where he is because I was there supporting him, looking after the children, running the household and doing whatever else a wife is doing. So I cannot walk away with nothing just because I wasn't doing the 8 to 5. So it's kind of, for me, it's a fair redress of the situation when a marriage comes to an end.
Arthur, can we go back to the first question regarding one spouse's name on the property and the other not? So I know ignorance is not an excuse.
Yeah, it's
ignorance of the But what recourse does the ignorant party have? For instance, there are so many dynamics that happen. For instance, when some migrate, the one it's so common here. The one spouse has legal standing in terms of paperwork, and the other doesn't. So the assumption is the one with legal standing registers the property, blah blah blah. But in actual fact, it's not like that. So there's so many reasons of getting to why one spouse ends up on the title deeds and the one and only one spouse ends up on the title deeds. So in that case, what recourse does the partner whose name is not on the documents have? Because it would be a lifetime. You know, it's sad either way, on death or divorce. Because on death, then you'll find out, okay, then this guy, gave away, or this woman gave away the house to whoever because they can do it. They can. Well, you said, and what the term, disinherit you. So what is the and also it's the assumption. Some assume, I've heard some assume that because the one who is contributing, or the one who has the debit order going off, the mortgage debit order going off, is the one who has the name there. But it's not true, but it has happened. So so there's so many, scenarios of why one ends up with all the rights to the house.
All right, I think you're actually asking the context of what's happening most likely in South Africa, is it? Laura? Hello?
Yes.
Yes, I'm saying, you are saying what are the available remedies in South Africa?
No, but this is for a marriage that was out of community, the Zimbabwean marriage, and
yes.
you've migrated, and you've migrated. So whether we've migrated to Australia or UK here on dissolution, whether death or divorce, the laws of the land that the marriage was registered prevail, isn't?
Yeah, pretty much. But I think, you know what, a divorce is much better because at least the other party is going to be there. You can raise, of course, depending with your jurisdiction, you can raise arguments like the unjust enrichment argument. If you have been able to demonstrate contribution towards that particular property, even though it's not necessarily written in your name, I think that's a remedy that is at your disposal. In certain setups, because you see, many women were invulnerable, especially I'm talking in the context of Zim, where they were in unregistered customary law setups, and the husband enjoys marital power over the property because recognized concepts of tacit universal partnerships and also unjust enrichment. So I really think, obviously I want to know what the legal system is in the particular area where the matter is being resolved. But generally, I think an unjust enrichment cause of action might be something that can be at your disposal. But I would have been much more comfortable for Shungu to respond to that, especially in light of the fact that she's much more familiar with the jurisdiction of the laws in South Africa.
Yeah. Okay, so we've seen this scenario playing out a lot with foreign marriages when they end in South Africa or when there's a death. What the court's approach has been is to try and rectify the situation by compelling the parties to come up with a settlement agreement. So in a settlement agreement, you're allowed to depart from what the norm would have been. It's when parties come together and say, okay, regardless of the fact that it's an out of community, I'm the owner of the property, but for the sake of fairness, we are going to settle on the basis that, okay, we will share the property, we sell it, we do a 50-50. So that's when parties agree to settle. Where settlement cannot be reached, the court steps in and uses its own discretion to make an order which is fair. So what the concept that Arthur is referring to of a claim of unjust enrichment, it's one where the wife would then be able to come and show whatever contribution they made. Laura made mention of debit orders coming off and things like that. If the wife whose name is not appearing on the property that was bought in South Africa is able to show that this was my contribution to the home, whether it's the debit order that was going off for the mortgage, or I was taking care of the lights, electricity, water, and whatever, or I'm the one who was doing the school fees, because if I had not done the fees, then you would not be able to pay for the bond, things like that. So there are ways in which, depending on how innovative your attorney is going to be, there are ways in which a wife in such a situation, or a husband sometimes in such a situation, is able to then argue their matter such that they convince the court that it's only fair that a redistribution be done in such an instance. And I just wanted to touch on the misconception Laura also mentioned regarding your status in South Africa. It's very common that we come as a couple, but the husband gets the permit before the wife gets the permit, and then they buy a house before the wife gets her permit and things like that. your legal status in South Africa does not prohibit you from being a co-owner, okay? That is why people in Zimbabwe are buying properties in South Africa. You don't have to be permanent resident in South Africa or having a permit in South Africa to own property here. You can own property anywhere in the world. So I want our women to be empowered enough to know and to make such decisions, that just because I don't have my permit yet does not mean I'm now excluded. I dealt with a case in my own family where one of my cousins used that argument to sideline his wife, and he's the only one who then signed as the owner of the property. And he then had to lie and say, I'm not married. Because the moment you mention that you are married, they're going to ask for marriage certificates, they're going to ask for whatever documentation is required. So I don't want, I want to encourage also the husbands or whoever has the bag at the moment, at that time, or has the legal status, just be honest, just be transparent in whatever you're doing, because these things have a ripple effect in the future. You leave your spouse impoverished. You don't know how long, what's going to happen, when you're going to die and things like that. And you'll think I'll sort it out, but life happens and things get out of control. So you need to empower yourself with as much information as possible so that you make the right decisions and you know what's what in the marriage. I see two hands. Mandy, yours came up first.
Okay, my question is, Shingu, we married in Zim, but when we brought our property here in SA, they said, I want to verify, I'm not sure. They said our marriage here in SA is regarded as in community of property. Is that it?
Yes, that's a generalization that they do when you apply for your bond. So on your bond papers, the ones I have seen on the application for the mortgage bond, they indicate there's a part where you say South African in community of property or out of community of property. Then there's a section that says foreign marriage. If you are married in a different country, you tick the part that says foreign marriage. They then make it an in community of property in converted mark, in whatever, just so that when the time comes that you default, they can come after your husband or they can come after you. So you are signing as almost like a surety to that debt that you're taking for the house. So that is just the bond aspect of things. The bond aspect of things is different from the ownership aspect of things. You'll see that when you purchase a property, there are two sets of documents that you're going to sign for the bond attorneys and for the transfer attorneys. Those are two separate issues. The bond is what is the security for the house. You are now an owner of the house, but the security is held by the bank. Until such time you settle with the bank, that's when transfer is done into your name. So, but your deed will still show that Mandy and husband are the owners of this property on a 50-50.
Okay, thank you.
So you need to be careful that you don't only sign as a co-debtor, sign as a co-owner.
It's difficult not to know which one you are signing to, because we just think everything is the same. So I'm
hoping that from this seminar you'll walk away empowered. Don't just go and sign things without reading them. Ask the attorney. Those documents are usually voluminous, I understand. Ask them, what am I signing for? When I'm putting my signature here, what am I signing to? Am I saying I'm just a co-debtor? Am I saying I'm a co-owner? Because you need clarity on that.
Is there a way of knowing after you've already signed, like we've already signed like 10 years ago?
Yes, you can ask a conveyancer to use, they've got access to databases where they punch in your passport number or your ID number and it shows you what properties are registered under your name.
Okay, thank you.
Yeah. Joy, your hand was up. I don't see it. Is it still up?
Yes, it is. Good evening and happy Sabbath, everyone. Thank you so much for this lesson. I really do appreciate it. I wanted you, Shungu, to repeat on what you talked about. I don't know how to articulate it. When you leave like an inheritance for your children, but you only want it for your children and not for your children's wives? I just wanted to check, but this is not what I'm going to do to all the other suitors out there for my children, but I just wanted to just find out there.
It's okay to do that. Okay, so what I was saying is that you can make specific provision to say, my inheritance to my daughter X is not subject to in-community of property or any marital regimes. So that will just mean in the event that your son, Joy, marries, 5 years down the line, when they divorce, your daughter-in-law cannot claim that property as part of the joint estate, because that particular property you'll have given to your son does not form part of the joint estate. He holds it as his own, and the wife is not a co-owner, unless he then makes a decision to donate it. But ordinarily, he's not. The daughter-in-law will not be a co-owner to this property that you've excluded from the joint estate.
Okay, and then you can just also stipulate that it will be for my sons and their children in that order and so forth and so on,
Yes.
correct?
Yes, and it goes down like that. Even your sons and their daughter-in-laws will be excluded and as it goes down. So the property sort of just stays in the family.
Okay, thank you so much.
Okay. I think if there's no other questions, I'll hand over back to Arthur.
All right, thanks, Shingo. I think I want to respond to a question where someone was asking about an executor. If you'd appointed an attorney as an executor, then he passes away.
Yeah.
So it depends at what stage. If he passes away before you pass on, you might need to revisit that bit on your will. But usually another way of doing is you can appoint two executors in the alternative. You provide that in the event that XYZ dies, then B, C, D becomes the executor. That way it helps you so that you don't have to go back again to revising. But in the event that they are all dead and they are dead, usually the master now has to appoint an executor so that the will is executed. So that's why I think it's also good for us to constantly revise and update our wills in light of the changes that will be happening. And by the way, if you divorce, your will becomes invalid. And if you get married, if you're a bachelor, a will also becomes invalid unless you've provided specifically that the contents will not be affected in the event of divorce, or alternatively in the event that I get married. So we always need to do that. So if you've got new kids as well, you might also need to update your will so that it captures the latest positions.
Okay, and I think also, sorry?
Oh, sorry, yeah, you can go on.
I was just going to touch on that aspect of wills. In the event that you get your will kept by your attorney and that attorney dies, that question also came to my private inbox.
Yeah.
That's why yesterday when Arthur was talking about wills, it's advisable to keep a copy of the will yourself, to have your bank keep a copy as well, and then your attorney. In Zimbabwe, they actually have their wills kept by the master. In South Africa, the master doesn't store wills. What you do is that when death arises, that's when you take the will to the master. So still, the advice would remain that don't just have one copy sitting with the lawyer. Have a copy yourself, store another one with the bank. With the bank, it's not about who dies or whatever. Just have the bank keep a copy for you. I think that is actually the safest. Have a copy for yourself, and then you can have one other trusted person who can keep a copy. Okay,
Laura,
back to you, Arthur.
Yeah, no, I was saying back to you, Laura. I think I had responded to the question.
Okay, are there any more questions, guys, or areas that you need clarity on? Now is the time.
There's a question that's coming through to me, anonymous. So what can a woman do in a case where husband told her, you cannot sign because you don't have a permit, so you cannot sign? Can you force him? I think Arthur touched on that right at the beginning. It's now a matter of the two of you guys coming to some sort of compromise. The truth is that my not having a permit as a wife does not affect my ownership rights. As long as I can produce a passport, there's nothing stopping me from being an owner to a property. So in terms of forcing, I don't know that. That's now something you have to find a way to work it out. Either accept that, you know, the guy doesn't want me to be a co-owner, or go for counseling until you come to a resolution that satisfies both parties. Back to you, Laura.
Okay. So what I'm getting, correct me if I'm wrong, guys, is that whatever situation that we might find ourselves in, unknowingly, or we want to correct, there's always a remedy. There's always what do they call it? What's the English? There's always a way to
Recourse.
to fight. Yes, there's always a recourse to fight for what you believe is yours.
For what the law allows.
Dissolution.
Yeah.
Yeah, whether it's divorce, whether it's death, there is. So it's not all doom and gloom. We have lawyers at our disposals, and we can use them. We can consult and work through things and work through. And for those who are still getting into transactions or doing things with their spouses, at least now you know what will be going on, what's cutting, and now you know when they say I think maybe I should be the only one signing, because then you know you're getting a road deal. Then you know something is going to go down. It will end in tears.
Yeah.
So there's a hand, Chipunzas.
Yes, thank you, Laura. I've got a question from Anonymous. It's a scenario that, say you're married in community of property and you have 2 children, right? And then later on, as the wife, you pass away, and your intention is for the children to inherit the house. They've got a share according to that formula. So on the death of the wife, the husband decides to remarry, and then somewhere along the lines, the fortunes of the husband maybe don't really then turn okay, such that he's forced maybe to like in quotes, sell the house to the new wife, or they are forced to be in a situation where the house has to be sold. So in those cases, what happens now to the share or that was left for the children? I hope it's clear.
Yeah, I got this question earlier. I'm sorry I'd forgotten to address it when we started. When you're married in community of property, upon your death, if you die without a will, your spouse, remember, is already entitled to 50% of whatever you own as a couple, right? The remaining 50% is divided between the 2 children and the remaining spouse, okay? So it's the formula is going to be the value of the property divided by 3, because in this case, we've got 2 children. So each of the 2 children should then get a third of the remaining 50% that was the mother's. If your estate is wound up correctly, then the deeds is going to update their records to show these new owners, which are the children, right? So if the remaining spouse remarries, he's still got his 50% plus that third of the 50% that he got from the wife's share. But the children are also now part owners with him of that property. So number one, that husband cannot sell that property without the consent of his other two co-owners, these minor children. And the interests of the minor children are usually, in South Africa, they're guarded by what is called the guardian fund. So it would be a fraudulent transaction if this man then goes and sells or donates the whole property to anybody else, regardless of the fact that he is now married to her. The children remain with their share of a third of whatever the 50% was. I don't know if I'm making myself clear. So the moment the wife dies, the ownership at deeds is updated once the estate is wound up to show that the owners are now the father and these two children. So when a new wife comes, a new wife is only going to have 100% share of what the husband owns in this particular property. So it can never be that the property is disposed of without the consent of these other two co-owners, which are now the children that were left by the first wife. Hey, what are you doing?
Hi, Shungu. So then can you stipulate that in the event that I pass on and then my husband remarries? Because if he then remarries, then the wife has a share to the 50% and the children have the other, correct?
Okay, Joy, if your husband remarries after you've died,
Yes.
he then gets the portion, she shares 50-50 of the portion that your husband now owns, which is no longer the full portion of what was originally owned by the two of you as a couple, because now Danny and Michael are co-owners to what the new ownership is.
And then if my husband then dies, then it will be my children and his.
Yes. Yes. And it's only fair because that share, Yagara, it's your husband, it's not yours. Remember, in community means 50-50.
So then can you have a stipulation on your property to say, should we remarry, then that property shouldn't be considered to the new husband or the new wife, it just stays with the children, whatever share it is?
Yes, you can agree
Can you
on
not
that.
put it that way?
You can agree on
Okay.
that and put it in a will. The scenario that we are dealing with, the way it was described, it's an in-community of property marriage, but the spouse died without a will. That's why it's divided this way. But when you put it in a will, you can specify who you want your 50% share to go to. When you've specified that my 50% share goes to your children, it becomes your children's to do with it what they wish. It can be a bit difficult to conceptualize it as we speak abstract, but if we had a diagram to actually draw it and show the method of it and how it works, it will be much clearer. But it's the short answer is that, like we said yesterday, you cannot give what does not belong to you. You can only give that which belongs to you. So the husband cannot go around giving to people things that now belong to his children. That's the bottom line. Back to you, Laura.
Chikunza, is that a hand?
It's well, I need to put it lower because for that question. Thank you.
Okay. Any more questions, contributions?
There's a question that came to my direct inbox. This one is saying, what happens to an illegitimate child if the child is left out in a will after the father passes on? So the terms illegitimate are no longer applying because of the constitutional dispensation. So there's no longer any discrimination. They are all children. So what happens is, if the child is left out, they're still entitled to the portion that the old deaf managed to, left out in a will. So what happens, remember, let me clarify this. So remember what we talked about in terms of disinheritance. You can disinherit. However, you've got an obligation to maintain. I think that's the point we need to stress.
Yeah.
So the child, whether legitimate or illegitimate, as long as they are below 18, they are entitled in terms of the Deceased Persons Maintenance Act. So they're entitled to get maintenance from the state. So I think this is the reason why, for all those men who are married, we might need to have the confidence to disclose that we've got other kids in other parts of the world. Why? Because it's not right to cause surprises, of which I think many men are very good at that. Very good at that. So a guy who used not to miss any Sabbath will shock you the moment they're gone. That, oh, this guy was also adventurous. So it's really, really not fair. But secondly, I also think, I'm not saying ladies, you should be smiling, whatever. But I think it's also good to say, guys, let's have honest conversations. Let's create an atmosphere where these conversations can be had. Very disturbing, but it's better for you to confront it during the person's lifetime than to be confronted with that setup when the person is no longer there. You'll be shocked. Some of the guys who look innocent, they're not that innocent. You'll be shocked. They just do things to ensure that you won't find it. But at the same time, guys, these things, they always find ways of coming out. Usually, I think you've heard of stories of people with children of same age. In Shona, they used to say, I'm a firstborn 3. So those things, and the next thing, they will just pitch up on death. So yeah, that's what I would actually advise. There's a question. Can you do a video recorded will? Our laws have not spoken on this, but I think it will be an interesting area. I'll need to explore that bit. Then I'll obviously share with Laura what's the legal position. Mind you, our Rules Act was done before all this technology we're using today in Zimbabwe. So they never anticipated a scenario whereby someone might just want to say, when I die, please play this video for everyone to hear. But in one way or the other, that same video needs to be transcribed into writing for record purposes. So that's why I think it's also still important to actually have your written will. If you want to read your own will, it's fine. At least there must be a transcript somehow. Yeah, that would be my thoughts on that.
So in South Africa, they do recognize the videos as last will and testament. If anybody then challenges it, the onus is on them to prove either that the testator, which is the person who did the will, was acting under duress, or that the video has been tampered with for some reason. But there hasn't been a lot of successful challenges to video wills. So I don't know, it's a trend that we see mostly amongst the very rich and famous. So yeah. I also wanted to touch on the answer you just gave now, Arthur, with regards to children born out of wedlock. The other consideration is that you have mentioned the entitlement to maintenance. So when it's children born out of wedlock in South Africa, children who are no longer dependents to the deceased, and they are left out of the will, they don't have an automatic right to claim anything. So if I'm an adult child and my father dies, but my mother was not married to my father and my father had his own family wherever, it's not an automatic right that I am entitled. It's like my father has expressed his will and that's the end of it. It's the same as if he decides to disinherit his wife. So
Yeah.
there's no valid challenge to such a will for a child born out of wedlock.
Yeah, there's a question by the Chupunzas. If you come across cases where wills are forged or someone signs under duress, how do you prove authenticity? Yeah, pretty much when you're making allegations that a will has been forged, the obligation lies on the person to prove that, on the person who's making that allegation. So pretty much that's when you need handwriting experts to indicate that this thing has actually been forged. So you need samples of the signatures of the purported testator, then that can actually help. Then things like duress, you know what? And this is the reason why wills have to be witnessed.
Yeah.
The whole idea of witnesses is we need to be very sure that this is the person who's making the will. Secondly, if you read the will, it also makes a declaration that this has been made freely and voluntarily, without any duress, coercion, or some sorts and so forth. The whole idea is that it has to be the will of the person. That's the whole idea of wills. It has to be the will of the person. So yeah, I think some of the safeguards which are available in terms of the law. But even better still, if you want to actually protect your will, you can even appear before a notary public and have your will signed before a notary public. It also makes it, it also gives it a lot of weight and ensure that whatever that you're going to come up with is not going to be subject to disputes.
Yeah.
There's a question.
Joy, just to backtrack a little on the questions of when one spouse dies, and I once administered an interesting trust. So this not to administer, I was managing that trust. So this guy, what he did, he set up a trust for to house his assets, his properties. He had a good portfolio property wise. So and then in his trust deed, because when you run the trust or whatever, you need to have an intimate relationship with the trust. So the trust deed was actually quite interesting when I read it, because it gave detail as to who the beneficiaries were and how they would benefit to the T. So he said that the beneficiaries will be his wife alone and his children and any children that are born in the, so then they had, I think, 2 kids, and any children born in the union between him and this woman. Any other child that is born out of this union will not be a beneficiary of all these things. And he went on to indicate and state in the trust deed how each beneficiary would benefit and to what extent. It was quite an eye opener for me, because it was more like a will, like, you know, it was writing exactly how he wanted distributions done, and they were done like that. And another interesting one that I also managed was this guy set up a trust for his children, and they specified which children, and the wife was not a beneficiary to this trust, but it had an end date. What do you call those trusts, Shungu? When you're alive. So basically it was to take care of his children, of his seed. He said it was to take care of his seed, and how and when they do this, and when each of them turns 18, was it 18? There was a certain distribution until, so you get to 18, your final distribution is done, and you are done, and you get struck off. and whatever. So there are ways of, if you really think, you know what, when I'm gone, or I don't want things to happen like this, even when you're still alive and you have these assets, put them where in a trust or whatever, and clearly state that, you know, I want this to run like this. I want the rentals from this property, or I want this income that's coming into this trust to be used to this seed or to this whatever, you know, the way you are thinking it in your head, put it down on paper. Yeah.
Okay, thank you, Laura, for that. So there are two different types of trusts recognized in South Africa. The one is the inter vivos trust. It's between living people. So the founder is a living person and the beneficiaries as well. And then there's what is called a testamentary trust. It sounds like what you described at the beginning, where you're sort of making a will, in terms of you're making a trust which explains what happens upon your death to the different properties that you own. It's called a testamentary trust. So that's just an explanation. What you've described, it's an explanation of two different trusts. And the trust gives you the liberty to explain exactly how each beneficiary should benefit, at what stage, how much, and things like that. However, it needs to constantly be updated to be in line with what's happening in reality. Otherwise, it will be difficult to enforce the wills or the intention of the founder. So I saw a question from Larry, which is asking which type of marriage is tax efficient at death, or they are all the same. I'm not sure if I understand exactly where you are going with this. Larry, maybe if you can explain it.
Hello?
Yes,
So
yeah.
I was asking, are there any tax benefits of getting married with one particular type of marriage than the other? As explained yesterday by Arthur, that there are 3 different types in Zimbabwe.
Not that I'm aware of, no. So in terms of, depending on what type of marriage you are in, if there are any tax implications arising from donations, what Arthur was explaining yesterday, I think he said in Zimbabwe, there's no capital gains tax if a husband donates a property to his wife. Am I correct, Arthur?
Yes, the marriage has to be registered.
Yeah, but there's no capital gains tax there. What I know in South Africa is that when there's transfer of property from any party to another, you attract a kind of tax. And the kind of tax is determined by the relationship between the person who is giving and the person that is receiving. So it's a whole other sector on its own, which needs proper detail in terms of what exactly you're looking at. Okay,
so what I meant, Tete, was that if like I'm married out of community of property,
yeah,
that my stuff is my stuff and her stuff is her stuff.
yeah.
So at death, when she assumes my estate or the portion of her estate, does she pay tax on the assumption of that particular portion because it's out of community of property? I would understand if it's within, it's considered to be different because we are sharing things.
All right. So let me answer that. The tax that is paid is estate duty. So once the estate duty has been paid, then the distribution plan has been done. There's no more taxes to be paid. So usually, if estate duty has been paid, or when you're dealing with estate transfers, you don't pay capital gains tax. So, but things like your stamp duty and others are payable. Yeah. So you don't pay any particular tax to inherit because the estate would have paid these taxes.
Yeah, it's the same position even in SA.
Thank you.
Okay. Guys, Shungu, this is a long consultation. Laura, what time?
I'm gonna start charging.
Now you have to charge. Would agree to an hour, you guys. The rest, you now need to come into inbox and pay consultation.
Do you have more questions on your side?
No.
Okay. Are there any other burning questions from the group? I think, like Arthur is saying, there are some situations which we cannot exhaustively explain in this session. What we can give is a general overview. If you do have a situation where you need to get legal assistance on, the best would be to set up a consultation with an attorney and explain particular circumstances so that you see how best you can be assisted. Because I believe that some of the answers we're even giving here are not even satisfying the people who are asking, because there's a lot to be unpacked when a situation arises. There's a lot of information that cannot be shared here in case you then disclose who you are. And then there's also a lot of backgrounds that you don't realize are important to contribute to how the answer is then framed. So it's very important that even after this session, if you still have something that you need legal assistance with, please get a proper consultation. Back to you, Laura.
Okay, thank you so much, Arthur and Shungu. This was quite an informative session and lesson. As we put it across, would say